obligation. We see that on 630 and 632 when the judge labels it a discovery question. And then the court discovered that question, and then the court considered the discovery objection. They just applied the wrong standard. They misinterpreted the statute, right? Because when they looked at it, the court said, well, all that's required is that the raw data be disclosed, when we know that 15A and 903 require disclosure of the actual expert's opinion, as well as the expert report containing the results of all examinations that underlie that opinion within a reasonable time prior to trial, which was not done.
How do you view the trial judge's gatekeeper functions in the absence of an objection?
Your Honor, for the Rule 702 issue?
And for the abuse of discretion?
Well, Your Honor, for 702, they are, so are you asking about the standard of review, Your Honor?
Well, we've already agreed, I think it's before us, that we're under an abuse of discretion standard of review. Do you agree with that?
No, Your Honor. For the discovery violation, we are asking this court to apply the de novo review because this is an issue of statutory interpretation. The North Carolina Supreme Court has looked at discovery violation cases in which there was a misinterpretation of the statute and determined that de novo review is appropriate. We see that in State v. Davis from the Supreme Court from 2016. And in that case, the court never reached the discretionary question of whether to impose sanctions because they misinterpreted the statute and determined that testimony that was coming before it was lay testimony when it was actually expert testimony. And so the Supreme Court said de novo review was appropriate. And that's similar to what happened here because the court never reached this discretionary question of sanctions. Instead, they misinterpreted the statute and focused on whether the raw data was provided, and if it had been, whether the defense should have been able to hire an expert and guess at what that evidence would be.
Go ahead.
So, as I understand it, defense counsel was provided with the raw data and also with an opinion of Agent Putnam, which indicated that the defendants were not present at the scene.
Correct.
Is that correct? And that is the information that defense counsel was relying on.
Correct.
And then from the record, it appears as though then the state met with Agent Putnam the day before he was supposed to testify and asked him for a new opinion. And then a new opinion was formed and given to defense counsel the night before the trial was to resume. Is that correct?
That's correct, Your Honor.
And you contend that's a discovery violation, even though the new opinion was formed the day before trial and given to defense counsel the day before trial, because why? Why do you contend that that is, in fact, a discovery violation?
Absolutely, Your Honor. The reason we contend that is because the focus in these cases is not on when did the prosecutor get this expert opinion. The focus is on when did the defense get it, right? Because we're looking at was it previewed and was there unfair surprise? And so State v. Cook is a great example of that from the Supreme Court. In that case, the state received an expert report on retrograde extrapolation the day before trial, and they also immediately disclosed it. And the court found that it was a discovery violation and that sanctions needed to have been ordered because the defense shouldn't have to guess at what the evidence was going to be. So the focus is not on when the prosecutor got it. The focus is on when the defense got it. And I will add, too, that this is, even more severe facts than Cook, right? Because to Your Honor's point, this isn't evidence that just fell into the prosecutor's lap, right? This prosecutor called in the middle of trial digging for new evidence. They said, quote, this is from 628 transcript 6, why don't we have any data showing that the phone in question pinged off that Kermit's tower? Right? It's like calling an FBI agent and saying, why doesn't this crystal substance I sent you, why isn't it positive for methamphetamine? Right? I mean, that's not typically how we go about this. So we do contend, too, that it's similar to Cook, but it's also a more severe situation than
So
Cook.
are you saying the state, there was a bad faith on the part of the prosecutor?
Your Honor, no, I don't think that we have to show bad faith. I just think that it was not provided to the defense within a reasonable time prior to trial.
I saw the
required.
word sandbagged. I saw the word sandbag in the briefs.
Yes, Your
What
Honor.
is your contention on being sandbagged?
Well, Your Honor, that language is taken from State v. Cook from the Supreme Court. And the contention is that they were sort of hit in the head with this new expert testimony that made or broke the state's case, right? There was no evidence placing them at the scene of the crime. And I think that is why, and it sort of brings us to prejudice, which is there was not probably enough evidence to convict, and let alone overwhelming evidence. And that's probably why the prosecutor called the agent right the night before his testimony, because I think the prosecutor was concerned that there wasn't enough evidence to convict here. There was nothing to connect the blue car found at Kermit's at the scene of the crime with the blue car found at Marble Street. So it was just two blue cars in Winston-Salem. So this new surprise evidence was pivotal, and it was quite a surprise to the defense. And the defense even told the trial court that they would have had a completely different trial strategy had they known about this evidence prior, right? Because this came in at day 6. It could have affected their decision to go to trial. It could have made them want to sever the cases, right? They wouldn't have had a need to have different trial strategies until this opinion came in. At trial, they had already committed to a theory of the case. They had already framed how they had already made key decisions about how they were going to frame the evidence. They were long past opening statements. They had cross-examined many witnesses. And so none of that could be undone. So it severely affected the trial strategy that this was not disclosed prior, and it also severely affected the outcome of the case because there just probably wasn't enough evidence to convict. And, Your Honors, I believe that is my time, since we're going to save the rest of the time for rebuttal.
What would you ask the court to do?
Your Honor, we're asking the court to vacate these convictions and for a new trial.
Okay.
I may have a couple questions. So you contend that the matters were joined for trial between Rush and Allen, is that correct?
Your Honor, I apologize. My hearing isn't good enough to hear you.
The matters were joined for trial, and so each party, Rush and Allen, had independent counsel, correct?
Independent counsel, yes, Your Honor.
All right, so is it your contention that because Rush's counsel objected on his behalf, that also counted for Allen, even though his attorney was there and could have joined in the objection?
That it counted for both?
Yes.
Your Honor, I acknowledge that it didn't count for both, and that's why we're asking the court to invoke Rule 2 to review my client's issues
What, if you're
using
going
the
to do
same
Rule
standard
2,
of
what is
review.
the extraordinary circumstance that we would invoke Rule 2? If the attorney was there and had the ability to object, what is the extraordinary circumstance?
Right, yeah, there's manifest injustice and extraordinary circumstances here. We just don't, I'm not sure what Your Honors have seen. I haven't seen any case law where someone's coming in on day 6 of trial after we're this far into making the cases and throwing in a new opinion. So it's a severe circumstance, and it made the difference, right, in the outcome. And I think that this connection between the two issues is important here to notice, which is that the discovery violation, right, because these defendants didn't get this evidence, they didn't have a heads up to think about the reliability issues in this case and how it would affect them and how they could mount a 702 objection. And they didn't think about how they could argue a discovery objection and that more was needed than just the raw data. And that's because they weren't noticed that this opinion was going to come in. That's a manifest injustice, right, for that discovery violation to put the defense at a disadvantage so that they couldn't mount a proper defense to this really pivotal evidence.
Okay. Thank you.
Thank you.
Thank you. We'll reserve your rebuttal time as well. Here from the state. Good afternoon.
Good afternoon. My name is Blake Norman with the AG's office. On behalf of the state, in this case, the state and the defendants want the same thing. We want a fair trial, free of error. And the state believes that that's what they got. This case is entirely focused on the testimony of Harrison Putnam, which was allowed under 702. Trial court had committed no error in admitting the testimony of Harrison Putnam. After a thorough voir dire hearing, found that his testimony was based on sufficient facts and data, product of reliable principles and methods, and those principles and methods were reliably applied. Second, that counsel for the defendants in those cases provided effective assistance by conducting a skilled and knowledgeable cross-examination of Harrison Putnam when he testified. And third, if there was any error, it was harmless, as there was a mountain of other evidence that was presented in this case that indicated that these two defendants did indeed fire multiple shots at Kermit's, hitting 3 people.
Let's talk about that third prong, the multitude of evidence, because when I read the record, I was of the opinion that it did appear as though the only thing placing these two defendants at the scene was in fact the cell phone data. So what do you contend is the other multitude of evidence?
Well, it's not, and we would admit it's not an ideal case for the state.
Well, there was no eyewitness, right?
There was no eyewitness, other than eyewitnesses that confirmed the vehicle and that the position of the people shooting in the vehicle. But there was an eyewitness that placed them in the vehicle, in the driver's seat and the rear passenger seat prior to leaving Marble Street. There was...
Of a blue car. Who identified the blue car?
I believe Asia Barnes did. That was the girlfriend. There was also the vehicle, when it was found, there was fingerprints in it from both Allen and Rush. There was broken magazine and ammunition inside of the vehicle. When Allen was found, there was a 9mm handgun. I think I went through in my brief and broke it down as to page number, everything there was in this case. But in the end, all that Agent Putnam testified to is not, as the defendants are trying to paint this, that he says that they were right on the scene based on these cell phone records. What any of these cell site things show is they were in this large area that had access to that cell phone, the cell tower. It's not triangulating the data to say exactly where they were. They were right beside Kermit's when this thing happened. It's saying that they were somewhere in the area. And I think that was fully presented to the jury. That was on cross-examination. Both attorneys presented questions about the fact that this is not triangulation data. This is just data showing the general area.
Would you concede, though, that when Officer Putnam's, when his first opinion was presented to the defense, that it indicated that the defendants were not in the area?
Well, it indicated they were in the area, just not, they didn't ping to the particular cell tower that one might have went to if they were right beside Kermit's, as what happened in this case.
So was
So
that
you
a
don't-
substantial difference between what he originally, what the state originally provided to the defense counsel and what was actually testified to on the 6th day of trial?
I don't know if I would say substantial. I would say it is additional information. And I think that this is being painted as something where the state is sandbagging or presenting this at the last minute without any idea. Trial by ambush has been said. They had this data for a month. It's a lot of pages, but it's not completely arcane. It's not something that you couldn't look at, see timestamps and figure out. You can look up the cell towers, you can figure out where these things are. And I don't think it's a matter where we can assume that the state is just digging for evidence at the last minute. And I don't want to presume what was going on in this case, but ADAs are very busy. And sometimes in the middle of a trial, you look at it and you go, what is the weakness of this testimony? And you go to your witness while you're doing your prep and say, well, why don't we have any data for this particular 4 minutes of time? And then your expert goes through and looks at it and goes, we do. And then instead of hiding that or trying to hit them in the middle of trial with it, Ms. Garrity called defense counsel immediately and disclosed this information, disclosed that that was what was going to happen, gave defense counsel access to Agent Putnam to ask questions. And then when there was a discovery objection made in this case, that we were just sandbagged with this. We didn't have information in advance, and the court asked them, did you have the information in advance? Were you provided discovery? They said yes, but that wasn't in there. And I go, well, maybe you should look over it and check. And then the court took a break and let them look at it, and then came back and asked them specifically on the record, did you receive that information? Was that in the discovery? And they said yes, it was. And then asked, well, do you have any objection then to this evidence other than the 702? And they said no. There's not a more explicit waiver that they could do as to this particular issue. They did.
So your counsel for the appellant has argued that we should review this issue de novo, as if from the initial review. Generally, admission testimony or admission decisions are reviewed for abuse of discretion. Do you agree with that?
Yes.
So which is the proper standard this court should look at this issue?
Well, I would say that this court should not even address this issue because it was not objected to on the record in any objection that was made.
So the state's first argument is not preserved, then it's not even properly before us. That's correct?
Right.
But if it is, there was an objection made by at least one of the counsel. You'd agree with that?
There was. That was
So
subsequently
if
withdrawn.
it's preserved, then how do we review it?
Well, I guess it goes to what the actual objection is. Because there was an objection made, and the portion with regards to the alleged discovery violation was withdrawn. The question or the way it was presented to the court is, we're sandbagged, we weren't given this information. Then, when the court addressed them on it, I mean, if that's the case, then the question is going to be abuse of discretion.
Let me ask this, under the Supreme Court case of Brady, the prosecutor is required to turn over exculpatory
Yes,
evidence to the accused, correct?
right.
Was the evidence that was provided to them, was it exculpatory?
No, it would have been inculpatory. I mean, I guess the court could consider it exculpatory under circumstances because it does have, it's complete. But the additional evidence, or I wouldn't call it additional evidence, the additional testimony and the information that was provided by Harrison Putnam during the trial is inculpatory. It indicates that at least these two defendants, or at least one of the two defendants, was somewhere in that large range that this offense actually occurred.
So your argument a while ago was this was not new information. This was an interpretation or review of the information that had previously been provided to them?
Yes.
Not the night before, but long before trial?
Yeah, long before trial. When the initial disclosure was made, it was made with all of the raw data that was involved in this case, as well as the maps and everything that are in the record, and a statement in there that says this may not indicate every, I'd have to pull the thing, but it clearly states that there may be other things that are not in this map that are indicated in the raw data.
So they could have had, defendants could have had their own expert to
Absolutely.
review the data?
Absolutely, or they could have run it through an AI, which would have done the same thing. It's just a matter of, they chose not to do that in this case.
Well, now, the state couldn't have presented this data to the jury without an expert to testify as to what the data said.
It would have been incredibly difficult.
And so the state had an expert, and that was Agent Putnam, right?
Right.
And Agent Putnam's report prior to trial said that they weren't in that area, that it didn't ping to this specific tower that we were talking about that would put in there beside Kermit's, right? They said that they weren't in that area. And so why would defense counsel have then gotten an expert witness to rebut something that was in their client's favor?
Well, they may have gotten, well, I think that they chose not to get an expert on purpose, but that you wouldn't do that because if you have the information as it was places them generally in the area, or it confirms at least what Asia Barnes had said. It doesn't place them as being close to Kermit's, as the handover data indicated. If a defense counsel then takes all that data and hands it over to their own expert, they could end up proving a part of the state's case for them. Now, it doesn't mean that you can't, and you don't have to disclose if you did and found out that it was the case.
So the initiation data would have been more specific on location?
Yes, but
And the
It's-
handoff data is more general area?
the testimony that was given by Harrison Putnam as an expert in this case was not, I would actually say the initiation data is also of a general nature, but it's, the handover data is when you move from one tower to another, all it does is tells you what the tower is and what the direction is.
And
then
the
that
time.
gets at the time, and then that goes over to the map, which is essentially what's happening with the initiation data as well. It's just a matter of,
But the towers do have proximity
to the
to
offense.
any, I mean, they're
Oh.
located, there's a specific place where that tower is.
Absolutely, but they're not right on top of each other such that you would be able to tell exactly where somebody is based on what tower they were using. No, I mean, there are other ways of finding that out, but they apparently weren't available in this
How do you
case.
find a cell phone when you lose it, if they can't pinpoint it?
Well, GPS, well, again, that's one of the other methods that you would use to find it, that was not available in this case. And I believe that Harrison Putnam actually testified that there are other records that would be more specific and could give more specific information, but they have to be turned over within, I believe, 30 days. He said somewhere in the record, but
So that's a retention issue, is that
it's
correct?
a retention issue, but there's also other applications, and this is outside of the scope of what we're supposed to be in here today, but there's other applications and things on phones that keep records, but unless they get the phone and do forensics on the phone, you can't do that. But you can get these records from the phone company, which is what happened in this case.
So looking at the prejudice, you're in the middle of trial, and the 6th day of trial, and all of a sudden you get a call, if you're counsel, oh, we just found this out. We found fingerprints, or we found a shell casing, or, I mean, what is the remedy that's available to a defendant to react to that type of new evidence, if you want to call it that, or a new interpretation of the evidence that was not apparent before?
Well, I mean, one of the main remedies is to object to it and ask to strike it from testimony, which didn't happen in this case. There was an objection.
Move for
and
continuance?
a withdrawal.
Move for additional time?
Move for additional time. to
Move
have
for
it-
mistrial?
You would move for, that's one of the things, but you would move for additional time to have it evaluated, or move for a mistrial for the period, for all the information that's come up before now, to allow the defendants an opportunity to review this. However, that was not done by either of the defendants, and the only objection that was made on the record was by Mr. Simmons, who objected to the 702.
Let me ask you this, if those are remedies that were available to trial counsel, and they chose not to exercise any of those remedies or to object, why would that not be ineffective assistance of counsel?
Well, because when you're presented with evidence that might be damaging to your case as a defense attorney, there's two ways to handle it. Either you get your own expert to look at it and fight it and say it's not true because of this, and this. But in this case, there was other corroborating evidence that placed them at least in the area about the time. So, I mean, any attorney who looks at this goes, well, it's not going to help or hurt me. It's not a good idea to spotlight it.
Well, there's no saying when the facts are against you, argue the law, when the law's against you, argue the facts, when both are against you, argue louder. Is that true?
That's good. Yeah, well, I suppose so. Oh, especially, coming from a defense attorney background. The thing is, what happened in this case, it was 8 days of testimony. And Harrison Putnam testified for a little bit over an hour. And a good portion of that is the defense attorneys asking him all of these very pointed and intelligent questions concerning how these records work, all the ways that these records could be wrong, all the ways that your phone might ping a tower that's further away because of interference, because of buildings in the way, because of signal traffic. What they did was instead of fighting this evidence is go, okay, your evidence is there, but it's not that important because it just shows they were in the area, and we admit they were in the area anyway, which is essentially what you do when you're defending these sort of cases and you have damaging evidence. You can kind of sweep it under the rug and don't call attention to it. In addition, they didn't present.
Is that the so what defense?
That's what I used to call it. But yes, Your Honor. And besides that, if they're not presenting other testimony, you give up any advantage of going last in closing. And they didn't.
But wouldn't we expect defense counsel to exercise every possible way to preserve the objection, or to try to keep it out, or to try to have more time, or to do something to offset, the lateness of the revelation to them?
You do within reason. It really depends on the performance of the defense counsel at the time when they look at it and go, well, how damaging is this? Because, it's one thing to make all the objections over and over again for the record, but you've got a jury sitting there, and their goal is to have a jury find them not guilty. It's not because it's a lot easier to get a not guilty than it is to get a victory and appeal. And in this case, these two attorneys are presented with this evidence that there's handover data that shows them somewhere in the range of this cell tower, which services Kermit's, in this 4-minute period of time. And their options at that point, and at least they had a long break to think about it, is to roll with it or object very hardly and try to get get a mistrial and start from the beginning with this new information to allow them the opportunity to review it. We would say that it seems that they went the second way, and it seems that they did so quite ably, given the cross-examination questions from Mr. Hines and Mr. Simmons in this case.
One of the tests for ineffective assistance is whether or not a similar attorney would have done the same thing. Was this a legitimate trial strategy? How could their failure to challenge it have been a legitimate trial strategy?
I think it's by the same reason that I was pointing to before, is when you see something that could be damaging. I think it would be different if they had something that said, we got GPS coordinates putting you right next to Kermit's when the shooting happened. They didn't have that. They just have something showing they're generally in the area, which corroborates this other evidence that's going to be out there. When you're given this thing that's going to indicate your clients are involved in the case, and that there's not really much that's going to happen, there's not going to be any change in the evidence, and they seem to be very prepared to cross-examine Agent Putnam on all the problems with this testimony anyway, that I think not just one reasonable attorney made the choice, two reasonable attorneys made the choice to just roll with it, and instead of delaying this trial to assess information that they already had and had the opportunity to assess before, they decided to go with the strategy of cross-exam or addressing all of the issues that are inherent with cell site location information through cross-examination, which is, again, what they did in this case. The other thing is, when they made that decision, they knew what the other evidence in this case was. And although we don't have a copy, we don't know what they closed with. This was presented alongside of other eyewitness identification, forensic identification, the physical evidence. I believe that there is not a reasonable, there's no reasonable possibility that there would have been a different outcome if this information that they were just generally in an area was not presented to the jury.
Well, it would have excluded an alibi defense, right?
I don't think that's true, because if they were 3 blocks away, that they would still have an alibi defense, and they didn't present one anyway. So,
Do you know, and you may not know, but do you know how wide of a geographic area or how closely it put them to the hot dog stand, the Kermit's?
I do not. I know that he testified just generally as to the area, and there's an indication on the maps that were provided that it's a very large area, but I mean, other than having an expert in here to testify as to what the signal length of that tower is and the likelihood that another tower would cross over it, I can't say. And it would have been nice if that was asked on the record, at least during voir dire, to give a better idea, but it certainly wasn't.
Were the maps shown to the jury?
I believe so. It was part of the evidence that was presented with Agent Putnam's testimony.
Now, the maps, though, didn't include the handover data. Is
They did
that
not. I think
correct?
he spoke additionally with regards to those 4 minutes or those 2 data points.
And looking at his testimony, I mean, on the issue of reliability, looking at his testimony, it seems as though it was testifying that handover data is something that's rarely used by state and federal. It's not always reliable evidence, but after he went back and looked at it in this 4 minutes, he can tell that there was some handover data. Tell me what kind of evidence you contend supports the reliability prong of the 702?
Yes, I can do that. When I guess during the voir dire in this case, he testified to his background. In fact, he testified 23 times, all that stuff. But he gives a very clear explanation of the process in this case, which is not, he simplifies it in a very beautiful way, saying that this raw data is just points on a map. And that he uses the software, and I think the software was a concern that the defendants have expressed in this case, but the software just takes that data and moves it over to a map. And the raw data includes the direction the signal is pointing, the cell tower, and all the cell towers have a assigned number, so you can look them all up and figure out exactly where they are, and a time. And then the software moves it over to the map, and then he checks each of the points on the map that are relevant, goes back and looks at the raw data, that's correct, and then there's an internal process whereby they review each other's work, which...
But now this one wasn't actually reviewed by anybody as far as the handover data is concerned, right? Because he had reviewed his report with the other data and the maps that he provided for the trial court, but on the day before this, when he went back and looked at the handover data, he didn't have that peer review, did he?
I don't see any evidence that that happened, no.
And he had testified multiple times, but didn't he testify he'd never used handover data before?
Yes, I believe so, but again, I think that they're trying to paint handover data as some sort of new or novel science. It's not, it's just data points in the same way that the initiation data is a data point. And we don't have information as to whether or not there was any peer review. I'm guessing there wasn't, based on the fact that it wasn't in the record, and it was kind of a last-minute thing. But it is the same process. The peer review is a double check to make sure that when they did the first time, that he's actually put in the right numbers or it's not correct. That's how it was showed when he testified. It's not a matter of, I think that they've pointed at 2 fingerprint cases, McFall and I can't recall what the other one is offhand, but when you're putting up a fingerprint expert to testify, you have them testify as to the background, and then you put up the defendant's fingerprint, and you point at this spot and this point, and they go through the whole litany to make sure that it's a 1-to-1 that you're not just pointing at somebody and the jury's going to accept it because you're an expert fingerprint person and juries believe fingerprints. This is different because it is, the expert part is explaining the way cell towers work, the way that cell towers have numbers, the way that the directions work, the areas that are covered, the fact that a cell phone could ping one tower that's farther away just because there's signal traffic, which is all the stuff that he's testified to, that I guess back up the reliability of the statements that he made. In all of those cases, and he even stated that some of the raw data can be unreliable, and we would say that that actually bolsters his testimony, and as much as he is able to look at these things and see when there's an inconsistency in the data and can know whether or not that's something that could be, I guess, should be something that a jury would hear. And in this case, again, his testimony is simply that these data points exist and the phone was in the area that pinged that cell tower. And this case is not about cell tower pinging. This case is about the other evidence. This is just a corroboration. This is another piece to support the idea that they were in the area at the time.
And I have one more question on the
Okay.
discovery issue. So your counterpart relies in part on State v. Cook in reference to the discovery being late and given immediately before trial. How can you distinguish this case from that?
Well, I don't think that this is, well, I guess this is not, in part, this is not intentional. I think that the attorney in this case, and there was some significant questioning and on the record about this from Judge Grine, as to why this happened. She stated that essentially was talking to the witness in preparation for trial, found this out and passed it on as quickly as possible. It's not a matter of the state intentionally withholding, and most importantly, these records were always there. The defense knew they were always there, had the opportunity to assess them themselves, and chose not to, we would say for a good reason. And besides that, withdrew their own objection to the fact that they received this, I guess, addition to the opinion during trial. They had the opportunity to ask for all sorts of relief outside of that, including mistrial, including to strike his testimony entirely, and instead said, no, we're not objecting to the discovery, we're just objecting to the 702. And in that, both of them didn't object, only Mr. Rush's attorney objected. I jumped around a lot, so I have to make sure I covered the stuff I needed to. Well, given the fact that I only have 1 minute, I appreciate your time, and if you have any other questions that remaining minute, I can give them a shot.
What would you have this court do?
We'd ask this court to affirm the trial court's ruling and find that there was no error in this case.
Thank you.
Just a quick question, just to follow up. So it's your contention that the state complied with the discovery statute and provided this cell tower data, is that correct?
Yes, Your Honor.
And the entirety of the time that both sides had this, the handover data technique existed, is that correct?
I'm sorry?
The handover data technique, that wasn't something new, that was available when everybody had the discovery, is that right?
Right, it was freely, it was in the handover data was in the record, or in the raw data that was provided, and it appears that defense counsel admitted to that on the record in open court.
Is it safe to say that the handover data is just a way of interpreting the data that was already available?
Yes, and only one of the three companies kept that at the time. I believe he indicated at trial that the other two are doing it now too.
Okay, thank you.
Thank you, sir.
Thank you.
Mr. Moore. All right,
Rebuttal.
we have rebuttal. One moment. I realize some of you folks may have class, and we'll just pause just one moment to allow you, if you need to leave. We thank you for coming, and we'll give you just a moment if you need to go to class to clear. We'd ask the rest of the folks to remain in their seats. You may proceed.
Thank you. Your Honors, I first want to clarify, the handover data places them at Kermit's, not just the general area. On page 724 and page 727 of the transcript, the expert is clear that it is consistent with them being at Kermit's Hot Dog House, which is the crime scene. So it's not just saying they're in the general area, and that's a problem with this new opinion. The second thing is with the peer review issue, the state argued that he was just saying someone else was plotting this out on a map. But what Agent Putnam testifies to on page 677 is that the peer review is using a second different software and maps it out by hand. He's doing a different analysis. It's not just looking at the exact same data and doing exactly what Putnam said. There's another process that happens. And then on page 667, Agent Putnam is clear that it's more than just mapping these points out on the data, that part of his expertise is determining what is reliable or unreliable handover data. And that's just not putting it on the map. He has to make a determination. But he doesn't explain how he determines the reliability. Again, that's when he's just saying, based upon my training and experience. And then going to the state's argument about prejudice, this was not a case of overwhelming evidence of guilt. And again, I think, Judge Wood, you mentioned how there were no eyewitnesses there were multiple eyewitnesses to the crime, but no eyewitnesses could identify the shooters. No one knew who was in the car at the time of the shooting, and none of them identified Mr. Rush or Mr. Allen as being in the car at the time of the shooting. In terms of the car, there was no one identified the license plate at that car, at Kermit's. And the eyewitnesses at Kermit's are clear. No one knows what the make or model of that car was. They don't know if it was a blue Hyundai, a blue Nissan, a blue Kia, etc. And so what we're left with is Asia Bain's testimony, where she says that Mr. Rush and Mr. Allen and two other people get into a blue Hyundai and drive away. That's her testimony. That's not overwhelming evidence of guilt. She doesn't know where they went. She didn't even know a shooting had occurred until after they were arrested.
What about the comments that their fingerprints were found, there was a weapon found, there was ammunition found? How do you explain that?
So the ammo was not, there was no evidence that that ammo was connected to the crime scene. The state's expert explicitly testifies that she doesn't even know what size that ammo was. So she doesn't know if that was the ammo that was found at Kermit's. And so, and I have the page site for that as well. And that's page 750 to page 51. And seeing my time is running up, you know, Your Honors, I am struck by the fact that as we are arguing here, we are standing in front of law students who came to law school because they believe in the fundamental fairness of this system. And they believe in law and justice and equity. And this case is the exact opposite of that. This is not how we want our future lawyers to act, by sandbagging the defense in the middle of trial. And so we ask this court to not uphold this conviction where there was surprise evidence based on unreliable data that experts do not rely upon in the middle of trial. And so we ask this court to vacate our client's convictions and remand for a new trial. Thank you.
Thank you. Thank you to counsel. We'd ask you to remain in place for a few moments if you have time. If you need to leave, we understand.